Maz has just said it when he's talking to Eddie.
All stand. Coronial Court is now in session. Please be seated. Mr. Rawson?
Yes, Your Honour, I flagged through counsel assisting the matter I wish to raise this morning in relation to what I anticipate to be the remainder of Sergeant Kirky's evidence. Yesterday we had some examination on matters relating to the use or misuse of body-worn video cameras, and a number of matters were put to Mr. Kirky in terms of general issues of malafide in the use of the cameras, and indeed, Your Honour, put some matters...
Sorry, Mr. Rawson, I'm just trying to get some papers out. Sorry to interrupt you.
That's all right, Your Honour. Your Honour also put some matters to Sergeant Kirky towards the end of the day in relation to the allegations that have been put to him concerning officers acting up on body-worn video and attempting to falsify evidence and so on. It didn't occur to me at the time, but it certainly did overnight. It's not a matter that Section 38 would cover in terms of the privilege against self-incrimination, because Section 38 of the Coroner's Act deals with certificates that can be granted by Your Honour to protect a witness from consequences in civil or criminal proceedings or proceedings otherwise of a judicial nature. Subsection 3. And it's not a matter of the privilege against self-incrimination at all. It goes to an issue of penalty privilege in terms of Sergeant Kirky and officers in a similar position being exposed to potential disciplinary action under the Police Administration Act. And that also goes to the anticipated examination in relation to the so-called racist text messages. And I anticipate counsel assisting will be seeking to extract from Sergeant Kirky and other witnesses concessions that their language is racist and unbecoming of a police officer, and having a tendency to bring the police force into disrepute, matters of that kind. Although I recall that counsel assisting at the outset of this inquest indicated that the purpose of the relation to text messages wasn't to demonise individual police. A number of adjectives have been used to describe what appear to be already accepted racist text messages have been referred to, I think, as disgusting and things of that kind. Disgraceful, thank you. So the line that counsel assisting obviously appears intended to pursue in relation to Sergeant Kirky and other officers in this area of body-worn video footage and the so-called racist text messages is to expose them and to put suggestions to them that they are racist, they see or observed or engaged in malafide in the use of body-worn video footage, matters of that kind. Those allegations put to the witnesses in examination would expose them potentially to breach of discipline proceedings under Section 76 of the Police Administration Act. Section 76 of the Police Administration Act defines breach of discipline, amongst other things, as engaging in disgraceful or improper conduct, either on or off duty. So clearly the text messages which occurred in some or many cases in an off-duty situation, captured by that, as will of course be alleged improper conduct in relation to the misuse or non-use of body-worn video footage. And third, paragraph C of the definition also includes a contravention or failure to comply with the provision of the Code of Conduct, that's the Anti-Force Code of Conduct, which is a very broad document and captures a very broad variety of acts and omissions which can bring about disciplinary action under Part 4 of the Police Administration Act. It's not to the point that these messages may have occurred years ago, or that the issues in relation to certain of the use of force incidents have already been investigated. What is to the point is that counsel assisting is here and now in this inquest, seeking to produce or discover evidence which would potentially bring about the disciplinary action under Part 4 of the Police Administration Act. The Police Administration Act procedures have a limitation period of 6 months. So that is a 6-month period which runs from the point at which the breach of discipline is discovered, not the time from which the actual conduct or the source conduct occurred. So what can, in my submission, can very clearly occur in this situation as witnesses such as Sergeant Kirby give their evidence is that their answers to questions, suggestions that have been put to them that they've been involved in nullifiers and use of body-worn video footage, that they've engaged in sending and exchanging racist text messages, all those kinds of allegations could potentially expose them to proceedings under Part 4 of the Police Administration Act. As I said, Your Honour, it's a bit of Section 38 deals with the privilege against self-incrimination, and in any event, it only provides protection for proceedings which essentially are of a judicial character. Proceedings under Part 4 of the Police Administration Act are not proceedings of a judicial character. At any event, in the very least, Section 79 of the Police Administration Act provides the Commissioner with the power of dismissal in the public interest without conducting an investigation or a procedure, and on the basis of the evidence that's sought to be adduced or discovered by counsel assisting examination of Sergeant Kirby and others, the Commissioner could act on that information conceivably and invoke Section 79 of the Police Administration Act. The question of 78, I'm sorry. The question of public penalty privileges considered in the decision with Bell and the Coronial of South Australia, which I provided through counsel assisting this morning, Your Honour, and Justice Blue, in that case, held that the Coronial had erred in finding that the South Australian Coronial abrogated penalty privilege. After quite an extensive analysis of the authorities, observed that it's a privilege which is distinct from the privilege against self-incrimination, and it's a privilege which has been long recognised by common law and equity, and it's a privilege that can only be abrogated by statute, by express terms or necessary intent. The South Australian Coroners Act obviously has some differences to the Northern Territory Coroners Act, but ultimately it's submission, and it may be something Your Honour's assistant for detailed and considered submissions on. I'm making this submission this morning after becoming aware of the authority last night, so I certainly haven't perfected my submissions in that regard, but Justice Blue did make some rather helpful observations in the context of the application of that privilege under the South Australian Coroners Act. So my submission is, Your Honour, it's a matter that Your Honour obviously need to rule upon the existence of penalty privilege for one thing. Obviously it's a matter that if it exists, Your Honour rules it exists, it's a matter to be raised, perhaps not as a blanket objection going forward, although it does seem that this is where we're going with the evidence of Sergeant Kirby. Once we got to that point yesterday afternoon with the body-worn video, we segued into the text messages relating to the alleged discussions about turning body-worn video off and that kind of thing. There are two other incident reports that the council assisting intends to go into, at least as informed yesterday. So it appears that we're now on that track of delving into generally issues of nullifiers concerning the use of body language and the so-called racist text messages. I don't know what else the council assisting intends to cover in that Sergeant Kirby's evidence. But as I said, Your Honour, it's a matter Your Honour will need to make a ruling on the existence of the privilege, and depending on that, I might need to set some instructions from my client as to where we go from there. Obviously, other parties, interested persons will want to make submissions on that, and I don't expect that they'll be ready to do so at least in a fully considered way, like myself this morning. It might be something Your Honour would be prepared to hold in abeyance and allow some further time for some submissions to be provided.
Are we ready, Your Honour, so that we don't hold up proceedings further? Mr.
Your
Coleridge will deal with the argument.
We're in a position to make submissions. We're happy to wait till after council assisting or whenever Your Honour wishes to hear from us.
Would you, sorry, and Mr. Bowes have to go either before or after?
I think you'll be assisted by Mr. Coleridge, Your Honour.
Okay, but Mr. Sumner?
The question, Your Honour, is whether you'd like to hear me, because the decision relates to my client as well, or whether you want to wait. I'm happy to address you also in a semi-prepared basis, but just to add slightly to what Mr. Robson has said, I'm ready to do that.
Yes, all right. Yes, Mr. Sumner.
Your Honour, the point of the Bell decision to which Mr. Robson referred is that penalty privilege is to be viewed equally with self-incrimination privilege. And that is a privilege that has long existed, that continues to exist, unless it is specifically legislatively ousted. In South Australia, when Bell was argued, Section 23 provided for an ouster of self-incrimination privilege by way of the offer of a certificate. The recipient of the offer of a certificate was obliged to take the certificate, he was obliged to answer the questions, and then, if he answered satisfactorily, then the evidence he gave to which he objected would be excluded. On that basis, Bell came before the Supreme Court in South Australia. And that is where the decision was made to which Mr. Robson's referred and which I have just explicitly identified what was found. Interestingly enough, within a year of the Bell decision, the South Australia legislature introduced a new section to the South Australia Coroners Act, Section 23, capital A. And what Section 23, capital A did was exactly what had been missing and what had been identified by Blue Jay in Bell. And that was a certificate provision for penalty privilege to overcome the problem of privilege stifling the proceedings of an inquiry, of a coronial. Now, in the Northern Territory, there is no provision for an amelioration of the penalty privilege. If it's raised and if it's equal to self-incrimination, incriminatory privilege, then when it's raised bona fide, it has to be honoured and the evidence has to be excluded. There isn't provision for a certificate. Now, if the law in South Australia on Bell is good, then it enables a witness over here to raise penalty privilege and to go from there to have it excluded. It appears that you, Your Honour, with respect, do not have the power, it hasn't been legislatively accorded to you to offer a certificate. Now, Mr. Robson made a point about the counsel assisting the coroner seeking to extract admissions about the conduct that may be self-incriminatory, even by way of penalty privilege. We say it goes a little further than that. Our client doesn't have to admit that it's racist or admit what he's done wrong. If through him documents are put in, questions are asked from him, which enable anybody to draw an inference that, given the answer he gave to the question that was put, it discloses conduct which is worthy of a disciplinary hearing, that would invoke penalty privilege. So what we've also heard via the interchange between counsel for counsel assisting and every witness that has been before you is putting a series of texts to you, and the question and the answer disclosing that they're racist, they're disgraceful, etc., etc. Those are the sorts of terms which invoke the code of conduct and disciplinary proceedings. Now, two other matters which come into the equation here. One is, even when you, Your Honour, are dealing with a self-incrimination privilege question, you would have to ask yourself, before you offer a certificate, whether the evidence in the wording of the statute is expedient for the purpose of justice. So over here, what you've got is a situation, and please believe me, you accused me last week of trying to reopen a decision you made. I'm not trying to do that. But I've got to make the point that the argument has been put to you that these texts from months before the Yundumu incident aren't strictly relevant to the inquest. In one of your recent findings, you held that it may be that at the end of the Coronial, it may turn out that these texts are not relevant. So my submission to you would be that on that basis, even if you were looking at self-incrimination, you would ask yourself, is reception of this evidence expedient for the purpose of justice? The other point I want to make to you about a recent ruling you made, when you dealt with the question whether an order you had made to keep things confidential should be opened up, and you dealt with most of the text messages, you dealt with my client together with certain other witnesses, and you dealt with them cumulatively and found the conduct evidenced by this to be racist and dishonest. Now,
Potentially.
well, in fact, your Honour puts the point better than I could have, because that's what's required here, is potentially. So potentially is there potential for disciplinary proceedings, and that would then invoke the privilege. Those are my submissions as to why you should exclude the questions. Thank you.
Are there submissions from Mr.
No,
Jones?
Your Honour, I just want to correct one aspect of Mr. Saylor's submissions. I think I may have misunderstood him, that before Section 23A was invoked as a consequence of the Bell decision, there existed a certificate process under the Coroner's Act in South Australia for self-incrimination. In truth, South Australia was the only legislation in the country that had no certificate provision at all. So what the position was at the time of the Coronial inquest in Bell was that objections were raised throughout under the guise of both self-incrimination on the one hand, and secondly on the basis of penalty privilege. That was overruled by the coroner at first instance, as set out in the decision of Justice Bell. Parliament then invoked section 23A, which provides for a certificate both in the context of self-incrimination criminal conduct and also in the context of penalty privilege. And so it covered both matters, but the significance of that legislative change in the context of the Morrison case was that it was not retrospective, which meant that the coroner could not invoke section 23A for the purposes of that particular Coronial inquest. But the point otherwise is well made, that is that if Justice Blue's decision is correct, the point that I think is being made by everybody so far is that the section 38 under the Northern Territory Coroners Act, whilst providing for a certificate, that certificate can only be issued in the context of self-incrimination criminal conduct. It has no application or capacity to, as it were, alleviate a person declining to answer questions on the grounds of civil penalty privilege in this Act, and that can only happen if Parliament's will is expressed in those terms and clearly and unambiguously.
I'm grateful for that correction, Your Honour. It was one that I was going to clarify with Mr Suttner. So,
As am I.
the position as it stood prior to the decision in Bell was that section 23 sub 5 in fact entrenched the privilege against self-incrimination and didn't partially abrogate it for providing for a scheme for the giving of a certificate. Now, we're in roaring disagreement with Mr Edwardson there, but I'll take you to some passages of Justice Blue's judgment in a moment.
Do I have a hard copy of that, or do I need to go online?
It's only one paragraph, Your Honour, so I'll be able to read it to you.
Mr Robson, do you have a copy?
No, I'm sorry, I don't have the capacity to provide.
We'll get one arranged as needed, because one is a very long judgment. I'll get it done.
I have
Direct access.
a copy of it.
Thank you, Your Honour. We were given notice of this objection at 8:47 a.m. this morning. That's not a criticism, but it means that I'm not able to provide Your Honour with a number of authorities and the second reading speech to the bill that inserted section 38 of the Coroners Act into that Act. Ordinarily, I would have provided them to Your Honour. The contention this morning appears to be, first, that the penalty privilege applies to coronial proceedings, and second, that section 38 of the Coroners Act does not abrogate the penalty privilege. And in support of that contention, you've been taken to a single case, the decision in Bell, which considered a different statutory regime. With respect to Your Honour, your counsel assisting's position is that the application fails for two reasons. The first is that my friends are simply wrong to assert, and I'll quote directly from Mr Suttner, that penalty privilege is to be viewed equally with the privilege against self-incrimination. In my respectful submission, there is a relatively significant body of High Court authority and intermediate appellate court authority in this country over the last 10 to 15 years that has drawn a very significant distinction between the two privileges. Unless an act confers the penalty privilege, it does not apply. And in my respectful submission, the penalty privilege does not apply in coronial proceedings because they are not proceedings for a privilege, for a penalty. Ultimately, Your Honour might not need to engage with that more esoteric argument because in its clear terms and having regard to the statutory context, it is obvious that section 38 of the Coroners Act abrogates the privilege against the penalty privilege. Before I turn to those matters, I do want to acknowledge where there is a concession, or at least a point of agreement, between your counsel assisting and the objecting parties. We agree that in theory, the penalty privilege can apply in disciplinary proceedings. And we agree that the giving of evidence about misconduct under a code of conduct could potentially expose a person to a penalty in disciplinary proceedings. So there'll be no argument to the contrary from us there. Your Honour, I'll take you to the first point, if I may, which is that the penalty privilege is not available in coronial proceedings. Now, in order to do that, I need to say something about the nature of the privilege against self-incrimination. Mr. Edwardson is quite right to say that it is a substantive common law right. It is not a rule of evidence, and that it is a fundamental common law right in the sense that it is protected by the privilege of legality. That means that if it's to be abrogated, partially or fully, clear words of necessary intendment are required. In my respectful submission, the position when it comes to the penalty privilege is quite different. First, in my respectful submission, it is not a substantive rule of law. It is an evidentiary doctrine that arose out of the chancery courts, so it is an equitable doctrine, and it applies only in the proceedings in which the penalty is sought. So contrasting it for a moment with the privilege against self-incrimination, where an accused can, in coronial proceedings, invoke the privilege against self-incrimination, the party who seeks to invoke the penalty privilege, it appears on the authorities, can only invoke the penalty privilege in the proceedings for the penalty. Now, they might be civil proceedings brought by one of the major regulators, disciplinary proceedings, proceedings brought against police officers, nurses and doctors for misconduct. Now, in my respectful submission, that is made tolerably plain by a series of High Court decisions, beginning with the decision in I apologise, Your Honour. The decision in Daniels Corporation, and then later the decision. I'll give Your Honour the citation. That's 2002 at volume 213 of the Commonwealth Law Reports, commencing at 343 at paragraph 31. And those observations, which I should note were made by 4 judges of the High Court of Australia, were picked up in Rich and the Australian Securities and Investments Commission. The report is 2004-222 CLR 129-24. The point thereon is made was there seems little, if any, reason that the privilege should be recognised outside judicial proceedings, and certainly no decision of this court says it should be so recognised, much less that it is a substantive rule of law. The point for present purposes, Your Honour, is that if it is not a substantive rule of law, and if, as we know, Section 39 of the Coroners Act provides that Your Honour is not bound by the laws of evidence, why would it apply in coronial proceedings? The next case, Your Honour, that I think it's necessary to take you to is the decision in Migration Agents Regulation Authority. That's not reported, but the medium neutral citation is 2018, Full Court of Australia, Full Court 5. Now, at paragraph 77, the Full Court of Australia, so the Full Court of the Federal Court, distinguished the penalty privilege and the privilege against self-incrimination in these terms. They said, following Sorby, the starting point for the privilege against self-incrimination is that it exists and applies unless abrogated. However, that is not the starting point for penalty privilege, which is not, following Daniels and Rich, the 2 decisions I just referred Your Honour to, a substantive rule of law, let alone an important and fundamental common law immunity, having as it does a very different origin and history. In each setting where penalty privilege is claimed, the opening question is whether the privilege applies in the first place, not whether it has been abrogated, and this emphasises the critical importance of considering carefully the statutory provisions in question, as well as the particular proceedings, the relief sought, and the particular adverse consequences faced by the person claiming the benefit of the penalty privilege. Now, these proceedings expose no one to a penalty. No penalty is sought. All that is sought from Your Honour is findings. It's not to the point that a penalty might be claimed against a person in other proceedings, because not being a substantive common law right, there's no reason to apply the penalty privilege into these proceedings. So that, Your Honour, is to answer, I think it's best described as an assumption made by my learned friends that the penalty privilege would apply unless and until abrogated. But even if Your Honour's counsel assisting is wrong in that, in my respectful submission, it is tolerably plain from Section 38 of the Coroner's Act that any penalty privilege would be partially abrogated by the regime for the giving of certificates. Now, in my respectful submission, there are 7 reasons why that must be so. One of those reasons is acknowledged by Justice Blue in the decision in Bell, and I'll take you to that passage in just a moment. The first reason is really to say something about the statutory context. The former Territory Coroner in the Northern Territory, Judge Kavanagh, had lobbied the government for many years because he perceived coronial proceedings to be frustrated time and time again by objections of precisely this kind. Those concerns, which were conveyed to the Legislative Assembly of the Northern Territory in writing, were picked up and read on to the parliamentary record when Section 38 was inserted into the Act. The purpose of Section 38 was described by the Legislative Assembly as being to ensure that the objectives of coronial proceedings were not frustrated by witnesses refusing to answer questions. And the purposes, as identified by the Legislative Assembly, were those of finding the truth about all circumstances of the death and the making of sensible recommendations in relation to public health or safety or the administration of justice. Now, in my respectful submission, it would be an absurd result if Section 38 operated so as to partially abrogate the privilege against self-incrimination, and yet this much more common privilege, and one which is equally likely to frustrate the purposes of the coronial, was not abrogated. Now, the second point, Your Honour, is that it is clear from the second reading speech to the Coroner's Act Amendment Bill of 2001 that the Attorney-General in fact turned his mind to the frustrating effect of the penalty privilege, not the privilege against self-incrimination, but the penalty privilege might have on the coronial process. The Attorney-General said, "The coronial process may also be frustrated where medical practitioners refuse to answer questions on the basis of self-incrimination." And he went on to note that the concern for these witnesses may not be that he or she may be charged with a criminal offence, but that civil or disciplinary proceedings may result from the giving of evidence. And so it is quite clear in my respectful submission that the verb criminate is not limited to criminal proceedings, but is being used loosely, I would have to accept, by the Legislative Assembly to describe concerns that a person might expose themselves to a criminal offence, but also concerns that a witness might refuse to answer questions because, and I quote, they might expose themselves to civil or disciplinary proceedings. Third, this is consistent with the comments made by the Northern Territory Law Reform Committee in support of the draft bill, that the policy behind the amendment is to get to the truth, and that as many witnesses are at inquests are more concerned about civil liability than criminal charges and guilt. And for that reason, the policy was more likely to be fulfilled if the certificate were extended to include any criminal, civil or other proceedings. The fourth point is apparent in my respectful submissions from the text of Section 38 itself. Now, it was submitted by Mr. Robson that Section 38 sub 3 can only apply in judicial proceedings with respect, that is to use the language in a somewhat loose fashion, the provision provides that the evidence given under certificate is not admissible in evidence in criminal or civil proceedings or in proceedings before a tribunal or person exercising powers and functions in a judicial manner. That does not mean that the proceedings are judicial in the sense that a court needs to be exercising the powers or functions. Indeed, the powers and functions can be exercised by a tribunal or other person. And what the Legislative Assembly is really saying there is that there needs to be some obligation, for example, of procedural fairness, of reasonableness and rationality. The fifth point, Your Honour, is, and I think it's one I've already made, that it would be an absurd result if Section 38 abrogated the privilege against self-incrimination but did not abrogate the less fundamental but arguably easier to invoke penalty privilege. The sixth point is that precisely this point was made by the High Court in Daniels Corporation and the Australian Consumer and Competition Commission. Now, that case concerned Section 155 of the Trade Practices Act. It was suggested that because the Act in terms abrogated the privilege against self-incrimination, it did not abrogate the penalty privilege. Now, the High Court said the implication that the privilege against exposure to penalties was abrogated by the section can be supported by reference to the absurdity that would result if the privilege could be claimed and, pursuant to another section, the privilege against self-incrimination could not. Now, I've noted, Your Honour, that we see the decision in Bell and Deputy Coroner is in fact supporting your counsel assisting team, and that is because precisely the same point was made by Justice Blue at paragraph 168 of the judgment. Now, the concession has been made that at the time of this decision, there was no certificate regime whatsoever. But Justice Blue turned his mind to what the position would have been had there been a certificate regime for the privilege against self-incrimination. And His Honour said, if Section 23 had abrogated self-incrimination privilege and legal professional privilege, an argument would be available that it was implicit that penalty and forfeiture privilege were also abrogated. So in my respectful submission, not only is the decision in Bell distinguishable, it was distinguished from this case by Justice Blue, on whose reasons our friends rely. We've got a copy of the decision for you, Your Honour. Can I ask you to pass that to Beck? So, ultimately, respectful submission. First, it is far from plain that the penalty privilege would apply in these proceedings because they are not proceedings for a penalty. And second, to the extent that it does, the penalty privilege is clearly abrogated by Section 38 of the Act.
Mr. Barrow.
Your Honour, I'll be brief. May I hand up a copy of the second reading speech? It's being circulated to the parties now. The current debate really does turn on how Your Honour interprets the phrase before a tribunal or person exercising powers and functions in a judicial manner, and with respect we adopt Mr Coleridge's submissions as to the word manner as against the submission made by Mr Robertson as to proceeding. But the important part of the second reading speech is the last sentence of the second paragraph, where it is said the objective of the Coronial inquest is to find the truth about all the circumstances of the death. And there's reference to the issue of frustration, but in the penultimate paragraph on the first page, it is said it is important to emphasise that the effect of the amendment is not to provide an indemnity from the prosecution or protection against civil action or disciplinary action. The witness could still be charged with a criminal offence following the inquest or the investigations taken with regard to civil or disciplinary action. It is just that the actual evidence given to the coroner cannot be used in subsequent proceedings. Now, in our respectful submission, if there is any doubt about counsel assisting's submission as to the word judicial manner, Your Honour should resolve it by reference to what the second reading speech foreshadowed as to the purpose of that provision, bearing in mind, and again, accepting that the provision must be read in line with section 41. Your Honour may order a witness to give evidence subject to section 38. The course Your Honour should take is permit any question to be asked if the witness perceives, or it appears to Your Honour, that the answer may incriminate or tend to incriminate that person. Your Honour may offer a certificate. The section doesn't require the witness to take that offer, merely that Your Honour offers the certificate, and thereafter section 41 permits Your Honour to require the witness to give evidence. So in a sense, those arguing against the position we take, with respect, kind of have it both ways. That is, if the Coroner's Act is read as not abrogating the right to claim penalty privilege, then section 38 should be read as extending to penalty privilege, not just self-incrimination privilege. It's hard to see why Parliament would provide a certificate for self-incrimination privilege but not penalty privilege. The alternative view, and if Mr Robinson's right, that the Act does abrogate the right to claim penalty privilege, because of section 41(1)(c), it empowers the Coroner, Your Honour, to order a witness to give evidence on oath subject to the offering of the certificate under section 38. So far, these very questions which Mr Robinson is taking issue have been asked. The witness has given answers. He hasn't yet sought to refuse to answer a question, although a discerning ear as to what he was saying suggested that he was concerned about answering questions when Dr Dwyer was pressing him with details of that incident. That was the time, if the witness chose to, or his counsel wished to, suggest that Your Honour consider offering a certificate. It seems that's what's being sought to be done now, and in my respectful submission, when a question is asked, Your Honour should offer the certificate, and from there we proceed to achieve the very purposes of this inquiry, which is to get to the truth of what happened, bearing in mind the focus of certainly my questions will be not so much of tricking or creating issues for this witness in terms of his memory, but rather look at what we need to know about Constable Rolfe's behaviour and conduct.
3 points, Your Honour, briefly. The first is that the Brown family support the submissions of Mr Bowe and counsel assisting. Secondly, we will circulate a article by Lachlan Blake and Brandon Lee, spelled Brandon Lee, L-E, for want of an effective Coroner's Act, Bell against the Deputy Coroner, South Australia 2020 SASC 59, and that's published in the Adelaide Law Review. And at page 387, the difficulties associated with the decision in Bell are set out by way of summary for Your Honour. Thirdly, if one needs any further support for the proposition that judicial manner will extend to disciplinary proceedings in this case, section 84B of the Police Administration Act suggests that a hearing for a disciplinary proceeding will be conducted in a manner where for example, person who is being disciplined is entitled to legal representation and so on. I can't assist you any further.
Can I just add one more thing to what I said before, and in particular about the submissions that were put on behalf of counsel assisting, and in particular paragraph 168 of Judgment of Justice Blue. That was the point that was made where Justice Blue said this: if section 23, of course that's as it then stood, had abrogated self-incrimination privilege and legal professional privilege, an argument would be available that it was implicit that penalty and forfeiture privilege were also abrogated. However, the non-abrogation of self-incrimination and legal professional privilege does not evince an intention to abrogate other privileges. The point that His Honour made, and has equal application to this legislation in this territory, is that Parliament has not abrogated, of course, the legal professional privilege. Now, plainly anybody could make a claim, valid claim for legal professional privilege in the coroner's court, and you would not be required to answer. And that would have to be subject to an express abrogation. The point that's being made by Justice Blue is that there are a whole host of privileges. And I think he even says that you couldn't possibly imagine how many there are. But the point that was made, and the ultimate decision, was that if Parliament does intend to abrogate a privilege, in this case the privilege that's been argued today, it must do so expressly or by necessary intendment. That hasn't been done in the context of this case. Secondly, the High Court cases and the tensions that exist between them are in fact dealt with by Justice Blue on a proper, careful analysis of the judgment, which I accept is lengthy, and he does go into it in some detail. Finally, insofar as our learned friends seek to rely on second reading speeches and the like, the last time I looked at statutory construction, and particularly in the context of no ambiguity, one looks at the legislation itself and looks at the words of the relevant statute and determines by reference to those words with what Parliament intended and what in fact has been achieved by the legislation, not what by politicians might have said in the context of why a particular piece of legislation is put forward on that basis. And finally, I'm not familiar with the no doubt academic article that learned friend Mr. Mullins has referred to in South Australia, but I'm not aware, and certainly I'll have another look, but I'm not aware of any decision per se that has dealt with or criticised what Justice Blue said about his analysis of the decision of the Coroner's Act as it then existed in South Australia. And finally, Your Honour, much like the arguments that have been advanced against us, in paragraph 194, the Coroner, at first instance in the Bell matter, advances a reason in support of the construction she adopted of the Act. If penalty privilege were available, the work of the court would grind to a halt. His Honour dealt with that specifically by saying there's no basis for such an assessment, or to impute to Parliament that it silently made such an assessment, and so on. And Your Honour will see that analysis of that particular paragraph. And finally, Your Honour, for the record, bearing in mind that Sergeant Rolfe will Constable Rolfe will ultimately be called upon to give evidence, the same issues likely to arise. So just for the record, I want to join on his behalf in relation to the issues that have been raised.
Your Honour, I haven't weighed in earlier. Can I just note, though, the Police Association does support the application made by Mr Robson, noting that Your Honour's ruling will obviously have an effect on a number of police witnesses who have given and who will give evidence in this matter. In addition to the matters that have already been raised, I would just like to note that, as Your Honour's no doubt aware, there are a range of disciplinary proceedings that are catered for under the Police Administration Act, not all of which are dealt with by way of hearing. And I note Mr Mullins specifically referred to disciplinary hearings being dealt with in a quasi-judicial manner. That, of course, doesn't apply to disciplinary proceedings which result in a person taking action, for example, separate from Part 4, or in circumstances where there are sanctions imposed where there is no hearing. I simply make that point, Your Honour.
Your Honour, may I respond to some of the points made by Mrs. Coleridge and Bow?
Yes.
First, Mr. Coleridge took you to paragraph 168 of the judgment.
Yes.
And it starts thus: if section 23 had abrogated self-incrimination privilege, those are the words that lawyers recognise as obiter. Those are not binding aspects of the reasoning of the judge. In fact, you would do better to move back firstly one paragraph to 167, where the judge said, starting with the text of section 23, it is not expressed to exclude penalty privilege, etc., etc. But then, to contrast the language of 167, I would take you back to 150. Because at 150, Judge Blow started with the following. The following propositions about claiming and establishing privilege in a curial context apply equally to penalty privilege, forfeiture privilege, and self-incrimination privilege. So, first of all, he deals with them equally, but when he deals with his reasons, or the basis, he says a witness who wishes to rely on the privilege must make a specific claim to entitlement to the privilege as a ground for not answering. Now, he qualifies that later, but the point is, here is the place where the point must be taken. That's the first point I want to make. The second point I want to make associates my client's position with a remark made by Mr. Edmondson about second readings. First of all, I associate myself entirely with what he said, but I would go one step further. What the second reading shows you is not what Parliament wanted, it shows you what the Attorney General said. It doesn't show you why people voted for or against a particular proposition. And, if I may say, I have also understood statutory interpretation to be look at the words of the statute. If you can't find what they mean, then maybe you can have a look at second readings and the like. That is not the case here. As it pleases you.
If I can just note one.
Can I have a go? Unless my friend wants to enlarge upon his submissions, or is he replying?
I was to add one authority.
I'll sit down.
Your Honour, to the extent that the decision in Bell stands for the proposition that penalty privilege applies in coronial proceedings, I want to make quite clear that the counsel assisting team's position is that the decision is wrong and will not be followed. Mr. Edwardson suggested that no case has since questioned the correctness of the decision itself that we're aware of. Now, that's for one very good reason, and that's because immediately after the decision, Parliament realised, my God, this scheme is unworkable, let's amend the Act so that the privilege can be claimed and the certificate given. But there is an intermediate appellate court decision that suggests that the submission we have made is correct and that Bell might be wrong. That decision is the decision of Attorney General and Borland, B-O-R-L-A-N-D. It wasn't reported, but the medium neutral citation is 2007 New South Wales Court of Appeal 201. And there, at paragraph 10, the court noted precisely the submission we've now made, which was that civil penalty privilege was not a substantive right, but a rule of evidence which did not apply at an inquest because Section 33 provided that the coroner was not bound to observe the rules of evidence. Now, Their Honours didn't need to decide this point because the case could be decided on another basis. But in my respectful submission, it's clear from the judgment that Their Honours were attracted to that proposition. They said the juridical status of the privilege, penalty privilege, awaits authoritative determination by the High Court, but the most recent dicta reject the view that it is a substantive right. Blue Jay in Bell found that it was a substantive right. And then the court goes on to quote, to Your Honour, the very same cases I've taken Your Honour to this morning, which are the decisions in Daniels Corporation and the decision in Rich. So I'd commend paragraphs 10 and 11 of the decision in Attorney General and Borland.
Right, just as a formality, I should add that we adopt what's been said by Counsel Assisting Mr. Bowe and Mr. Martin.
Your Honour, that was also the position of Marja.
Thank you. Mr Robson, you
Oh,
had something
just briefly
to add.
in relation to Mr. Coleridge's submissions that, as I understood them, that it's not a substantive rule of law, it's an evidential doctrine that applies only in proceeding in which the penalty is sought. That, of course, is contrary to the ruling of Justice Blue in Bell, and at paragraph, it doesn't appear to be supported by the decisions in Daniels Corporation International and Sorby decision of the High Court that Mr Coleridge referred to. Your Honour will see at paragraph 139 of the judgment in Bell, Justice Blue refers to a passage from Daniels there, and the passage, amongst other things, states that the privilege is one of a trilogy of privileges that bear some similarity with the privilege against incrimination. Goes on to say, finally, that it is clear, as noted by Acting Chief Justice Justices Wilson and Dean in Pine Board, that the privilege against exposure to penalties has long been recognised by the common law and is no longer simply a rule of equity relating to discovery. And then further, at paragraph 156 of the judgment in Bell, Justice Blue refers to what flows from the decisions in Pine Board and Sorby, and concludes in that passage that the approach formulated was that penalty privilege was not abrogated by the statute in the absence of express provision or necessary intent, which runs counter to the counsel assisting submission that the first question is whether the Act preserves or maintains the privilege, rather than what we say is the relevant question: does the Act expressly or by necessary intent abrogate a privilege which has long been recognised by the common law and equity? And indeed, of course, in Bell, it was held that the penalty privilege applied to the Coronial inquest in light of the disciplinary action that might flow subsequent to the evidence given by those witnesses. So there's certainly no warrant to read from the decision in Bell that it's a privilege that only applies to a penalty imposed in the particular proceeding. It's a privilege, according to Justice Blue's analysis, which applies to proceedings that may flow later or from the inquest which expose the witness to a penalty. And in terms of, in terms of the actions that can be taken under Part 4 of the Police Administration Act, of course, the reference made to the hearing procedure provided for by Section 84 capital B, but of course, in the very least, the Commissioner under Section 78 can effectively summarily dismiss a police officer. In other jurisdictions, it's referred to as a lack of confidence direction or something of that kind. In this jurisdiction, it's public interest dismissal. But all the Commissioner has to do there is take into account a written response from the member after service of a Section 79 notice. In my section, that is not a process which would come within subsection 3 of Section 38 of the Coroner's Act, which would fit the characterisation of a person exercising powers and functions in a judicial manner. So there is a gateway for the evidence to be used to be released by the Commissioner to invoke Section 78 and dismiss police officers on that basis, Your Honour.
Your Honour, I rise only to join the debate in a very modest sense, to provide some information to you. In the supplementary affidavit of Assistant Commissioner Porter, affirmed on the 2nd of September of this year, you will see in annexure BP07 that Sergeant Kirkby has received remedial advice in respect of the text messages involving himself. And my instructions are that Sergeant Bowens has similarly received remedial advice in respect of text messages, and he received that advice on the 21st of September of this year.
That doesn't mean that the Commissioner is barred from taking action subsequent to this inquest and the evidence and whatever comments Your Honour may make in light of the evidence to invoke Section 78.
We simply say that there are real limitations to the proposition just advanced by our learned friend. Certainly the police officer cannot be proceeded against in two different ways for the same conduct.
Yes, obviously need to adjourn to consider those submissions and the decisions that I've been referred to. Did you have something else?
Your Honour, I was just going to ask, because of the timetabling that's affected by these matters, that for our part we would be content with Your Honour announcing a ruling and publishing reasons later, rather than needing to explain everything in the very comprehensive way Your Honour has done in the other rulings, because if we hold this up now, we're going to lose so much more time, which is really affecting the families in terms of being able to assist Your Honour with these witnesses.
Yes, if there's nothing further, I'll adjourn. I might just adjourn for a sort of longish morning tea, and it's certainly at the end of that I'll give you an indication of the timetable and where you might proceed from there. So we'll adjourn till 11:30.
All stand.
Thank you.